Welcome to The Explainer. Today, we're going to walk through Cambodia's official law on insolvency, step by step, to figure out what really happens when a business just can't pay its bills anymore.
All right, let's jump right in. Picture this. It's the kind of scenario that probably keeps a lot of entrepreneurs up at night. Your business is in trouble, the debts are stacking up. So, what happens? Is it just a mad dash, a chaotic scramble for whatever assets are left?
Well, the good news is no. It's not chaos at all. Actually, Cambodian law lays out a very clear, very structured path forward. The whole system is designed to be orderly and, as fair as possible for everyone involved, from the business owner right down to the smallest supplier.
Okay, so what's the trigger? What's the thing that officially kicks this whole process off? I mean, what does it legally mean to be insolvent?
It's not just about missing one payment or having a tough month. Insolvency, that's a formal legal status. It's when a court officially declares that, this company is fundamentally unable to meet its financial obligations.
And there's actually a specific number that really matters here. According to Article 7 of the law, once the unpaid debts hit 5 million reals, which is about, say, $1,200, that's the magic number. That's the financial trigger that can officially get the whole insolvency process started.
And this quote really gets to the heart of the law's two main goals. It's a total balancing act. On one hand, you've got to make sure the creditors, the people who are owed money, get paid back in a fair and orderly way. But, and this is just as important, the second goal is to try and rehabilitate, to try and save the business if that's even a remote possibility.
So, once that trigger is pulled, how does the process officially get going? Well, it all starts with the very first formal legal step, filing a petition with the court.
Now, what's really interesting here is who can actually kick this off. It's not just the creditors, banging on the door demanding their money. The business itself, the debtor, actually has a legal duty to file for insolvency within 30 days of realizing it just can't pay its debts.
And the second that petition is filed, a very, very strict legal clock starts ticking. Bam! There are hard deadlines for submitting all the paperwork, for holding a court hearing, and for scheduling that first big meeting where all the creditors get together. The whole process is designed to move fast.
Okay, so once the court gives the green light and officially opens the proceedings, a new and very powerful player enters the game.
This right here is an absolutely critical moment. The court immediately imposes what's called a stay of action. And you can think of this like hitting a giant pause button on everything. Every single lawsuit, every collection attempt, every angry phone call, it all has to stop. It freezes everything to prevent this chaotic race where everyone's just trying to grab assets.
So, with everything on pause, the court then gathers up everything the business owns into what's legally called the estate. We're talking everything, all the property, the cash in the bank, the inventory, even legal claims the company might have against other people. This estate is now the center of the entire universe for this case.
And who gets to manage this estate? Well, it's not the original owners anymore. The court appoints a totally neutral third party called an administrator. And this is the exact moment when control of the business and all its assets officially changes hands.
And let me tell you, this administrator has some serious power. We're talking sweeping powers. They can keep the business running, they can sell off property, they can represent the company in court, they can even go back and unwind shady-looking deals that happened right before the filing. Basically, their one job is to manage the estate in a way that's in the best interest of all the creditors, not just one or two.
All right. At this point, the whole process reaches a huge fork in the road. The administrator, along with the creditors, has to make a massive decision. And there are two very, very different ways this can go.
So the choice really boils down to two paths: rehabilitation or liquidation. Are they going to try to save the company? Come up with a restructuring plan that's called a plan of compromise and try to make a go of it? Or is the business just beyond saving and the only real option left is to sell everything off piece by piece?
But choosing to try and save the business, it's not that simple. It's not a decision one person makes. Any plan to rehabilitate the company has to be voted on and approved by the creditors. Yep, the very same people who are owed all that money. If they don't buy into the plan, if they don't think it's going to work, it's a no-go. It's kind of like a democratic process, which then, on top of all that, still needs the court's final stamp of approval.
So, regardless of which path they choose, how does this whole journey finally end? For the business and for everyone it owes money to?
Okay, so if the company is liquidated,
If they go down that path, the money from selling everything off isn't just thrown into a pot for a free-for-all. Nope. The law creates a very strict pecking order for who gets paid, and has a real logic to it. First up, you cover the costs of the whole process, and importantly, employee wages. You've got to protect the people who actually work there. Then come the secured creditors, think banks with collateral. After them, it's state taxes. And finally, way at the end of the line are the unsecured creditors, like all the suppliers and vendors.
And this really highlights a key principle of the law. The whole point is to satisfy the debts, not to punish anyone. If, and it's a big if, but if there's any money left after every single creditor has been paid back in full, that surplus goes right back to the original business owner.
So, in the end, you land in one of two places. Either you have a successful rehabilitation and a new, restructured business emerges to keep on operating, or you have a liquidation, where the company is officially dissolved and its assets have been used to pay off as much debt as possible.
And this brings us to one final, and honestly probably the most important question, especially for an individual entrepreneur. If the company is liquidated and there just isn't enough money to pay everyone back, are you personally on the hook for that leftover debt forever?
And this is where Cambodian law provides a really powerful answer. Under Article 64, individual business owners can actually apply for a release from unsatisfied claims. Now, what does that mean? It means that as long as they acted in good faith, as long as they were honest, the law offers a true financial reset, a clean slate. It's a path that allows an entrepreneur to learn from what happened and to get a chance to start again.